All right, good morning, everyone. I'm Judge Corey Amanda Cawthon, and this is First Appearance Court. Today, I will let you know if I have determined probable cause, and we will talk about release conditions. As a reminder to everyone, today is not your trial date, and I do encourage you to speak to your attorneys before speaking on the record this morning, because everything that we say here is being recorded and can be used against you at a later date. For those of you represented by the Public Defender's Office, know that attorneys from the Public Defender's Office are present here in the courtroom with me and are available to you by phone. For those of you represented by private counsel, please know that your attorneys also come here to the courtroom with me and are able to address your cases from here. If your attorney is not in the courtroom when I call your name, you can let me know that, and we will see how we can help facilitate that process for you. However, I ask you not to tell me that you have private counsel unless you or your family have already retained counsel for this specific arrest. You also need to know that in the courtroom with me, I have present attorneys from the State Attorney's Office, as well as representatives from Confinement Status, Pretrial Supervision, and the Clerk of Courts. All of these persons are here to help facilitate this morning's session and to provide any additional information that may be needed. Some of you may be able to resolve your cases here this morning if you are present on misdemeanors or municipal ordinance matters, but understand that is dependent on what is going on with you personally and with your case. For those of you present this morning on felony matters or violations of probation where the judge has already set a no bond hold, please know that those cannot be changed or resolved here at First Appearances. Going forward, your case will be assigned to a specific division judge, and all pretrial motions and any subsequent trial will be heard before your division judge. As a matter of housekeeping before we get started today, I do have two cases at the beginning of the docket that North Broward has requested to be called at the end. I've already taken them out and placed them at the end of my stack here. We have a couple of cases that we are going to be using Zoom for at the main jail today. We may have to take a break briefly at the beginning of the docket so that we can get that set up, but we'll try to keep things moving as smoothly and efficiently as we can this morning. As we are getting started, the first on my list for now is going to be Christina Cusimano. She's a medical reset? Or is this Miss? All right, this is Miss Cusimano. Good morning, Miss Cusimano.
Good morning.
All right, Ms. Cusimano, you are before the court this morning on 4 charges. Count 1 is disorderly conduct. Counts 2, 3, and 4 are related to a misdemeanor warrant for a violation of pretrial. I find probable cause. Do the parties wish to be heard? One moment, Ms. Cusimano. Let me hear from the attorneys first, okay? All right. Defense, do you wish to be heard on her case? Guys, I'm just going to ask you to make sure your button is on and pull that mic down so that you can, because it's not very loud.
Your Honor, I have an offer if she wants to.
You have an offer on
Yes.
both?
On
A global offer? Okay,
Your Honor, it'd be a withholding court costs on all counts.
for all of it.
Yes, just so and if she wants to accept it, she has to understand, because there's similar outbursts in both cases against law enforcement.
Okay.
I would prefer not to see her back here again.
Okay, so Ms. Cusimano, right now you've got 2 cases. You have the new charge that you're on, and you have the other charges that are related to the warrant that I discussed with you. Mr. Linder from the State Attorney's Office is saying that the state is willing to make an offer to you on both cases, which would be a withhold of adjudication plus court costs. Do you understand that?
Understand, what does that mean?
Okay, so why don't I do this?
Court cost is assessed fine, that I understand.
Okay, a withhold of
costs.
adjudication, is that what you're asking me?
Yes.
Okay,
To explain that.
a withhold of adjudication means that there would not be a conviction on your record. If someone
Okay.
were to look and see, they would see that something happened, but it would not be a conviction. Does that make sense?
Okay, so I wouldn't be convicted, found guilty, all of that, it would,
It would be a withhold of adjudication, correct? Okay?
okay.
All right.
I'm just making sure I understand correctly, that's all, I'm just clarifying.
Okay, that's fine. I want to make sure that you understand too, okay? All right, do you want some time to speak to the public defenders about it? If you have any other questions, you want to talk to them privately?
No.
Okay, all right. So what I'm gonna do is I'll ask you a few questions before we finish today, okay?
Okay.
All right, so to begin, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you. And now you can go ahead and put your hand down. And Ms. Cusimano, do you understand everything we've discussed so far this morning?
I do.
Is anyone forcing you to resolve these cases?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
Yes.
Is there anything about that illness today that impacts your ability to accept this plea?
No.
Okay. And do you understand that if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes.
All right. And Ms. Cusimano, what plea do you wish to enter, guilty or no contest?
No contest.
All right. I accept your plea and find that it is freely and voluntarily given. So once again, your sentence as to both matters will be a withhold of adjudication plus court costs. All right. Thank you very much, ma'am. Good luck to you.
Thank you.
All right. Okay, do we have them ready at Maine?
Right?
Can you hear me?
Yes, we can hear you. Are you ready with them?
I have the inmates here. You just gotta let me know which one it is, and then I'll get them.
Okay. I've got the ones, I'm going to let the public defenders speak to them off the record before we actually do their hearings. But there's 5 on my list. I'm only doing 3 of them, and then the other 2 Judge Malika is addressing after we're done for extraditions. So I've got, the 3 that I have are Jesus Carrion, John Tcax, and Christopher Pinkney.
Let me do Jesus first.
Okay. All right. I'm going to go off the record briefly so that the public defenders have the opportunity to speak to these individuals privately, and then we'll come back on so that we can proceed with their hearings. All right? All right, so we're back on the record. We have 3 cases to do like this. We're going to do them one at a time. I'll go off the record in between each case so that the public defenders can speak to them privately and we can facilitate their transportation through at the jail facility. So I'm just going to ask everyone to speak loudly into the microphones so that they're able to hear you at the main jail. The first case that we're going to address is Mr. Jesus Carrion. I've already found probable cause in this case, so we're only addressing bond issues today. I'm going to hear the state's recommendation first, and then I will go to the defense for their response.
Thank you, Your Honor. Your Honor, I'm going to be requesting bond and release conditions in the following amounts. Count 1, $250,000. Count 2, $50,000. Counts 3 and 4, $25,000 each. Pretrial release with a GPS monitor, level 1, no victim contact. Your Honor, first I would note, count 1, while only charged as a first-degree felony based on the allegations, I would argue for bond purposes that the allegations would support a punishable by life offense, considering the allegations that he used a weapon to threaten the victim while committing the sexual assault, specifically a knife, and threatening to scalp her. Our office had contact with the alleged victim in this case. She advised us she is in great fear of Mr. Carrion. He has threatened to kill her on multiple occasions. He has gone so far to threaten to kill her parents in New Jersey. He has a criminal history involving domestic violence, Your Honor. Specifically, out of Dade County, 2010, aggravated stalking, violating a court order, 2 counts of false imprisonment, burglary with an assault, child abuse, tampering with a witness in a punishable by life offense, false imprisonment, domestic violence battery by strangulation, and tampering with a witness in a third-degree felony case. On all cases, he was sentenced to 4 years in Florida State Prison. Nothing further, Judge.
All right, thank you. I will now go to the defense for their recommendations.
Yes, Your Honor. Mr. De Jesus has been in Broward about 6 years. He works in asphalt. He would, as far as he knows, have a job whenever he returns. He came over to Broward to get fires testing, and the max amount of bond that he could afford would be $1,000. He would stay away from the victim, Your Honor, if you were inclined to release him on an electronic monitor in the meantime.
All right.
And Your Honor, I'm sorry, that in response to the state's PBL allegation, he's not charged with the PBL here. They are free to charge him as they wish. They didn't seek to do that.
Okay. All right, based on the severity of the allegations in this case, and I understand that the defense has said that the most that Mr. Carrion would be able to afford is $1,000. This may be one of those cases where it's more appropriate to have a lengthier hearing with the division judge to determine more appropriate as far as his financial means and things like that go. Because based on these allegations, I will tell you that his bond is definitely going to be greater than $1,000. So in light of the fact that I believe if he's not going to be able to post more than that, this will have to be addressed with his division judge ultimately anyway. For today's purposes, I am going to grant the state's request. The bond on count 1 is going to be set at $250,000. The bond on count 2 will be set at $50,000. The bond on counts 3 and 4 will be set at $25,000 each. If Mr. Carrion does post that monetary bond, then he will be placed on pretrial supervision with a level 1 GPS monitor. And in the meantime, and in an abundance of caution, there will be an order of no victim contact. Mr. Carrion, it's very important that you understand the no contact order means that until a judge says otherwise, you're not to be in the same place at the same time as the alleged victim. That also means no phone calls or text messages to this person and no third-party contact or social media contact with this person. Do you understand that? Yes, Your Honor. Okay, all right, thank you, sir. That's correct, yes. Okay, all right, thank you, Mr. Carrion. Good luck to you, sir. All right. So now our next case is going to be John T. Cax. I'll go off the record briefly for a few minutes, and then we'll come back on so that we can address that matter. Okay, we're back on and ready to address our next case. This is going to be for Mr. John Tcax. I hope I'm pronouncing that correctly. All right, Tax. All right, thank you, Mr. Tax. All right, I have already found probable cause in this case, and so today we are here to address bond and release conditions. I'm going to begin with the state and their recommendations, and then I will go to the defense for their response and recommendations as well. Mr. Linder, go ahead. Okay.
I've got it. I just. All right. Sorry, Judge.
All right, go ahead.
Your Honor, I'm going to be requesting a $10,000 bond on count one, a $5,000 bond on count two, $1,500 bond on count three. This is based on the level of violence alleged in this case. This is also based on the injuries that have been documented that the victim suffered as a result of the attack by the defendant. I would also note that
Mr. Tax, I'm gonna ask you not to say anything right now, okay? Just listen. I don't want you to say anything that would be harmful to your case. So right now, just listen. I'm hearing from the state attorney at this time, and then I'm going to hear from your attorney after that, okay? So I'm just gonna ask you to just listen, okay? All right, go ahead, Mr. Linder.
Thank you, Your Honor. He was arrested for domestic violence battery against the same alleged victim in early January of this year. Now, the charge was dropped in late January. One thing, after reviewing the probable cause affidavit that I think the court should be aware of for purposes of this hearing, when law enforcement arrived at the scene, Mr. Tcax answered the door, and he advised law enforcement that he was involved in a verbal altercation with his wife, Ms. Williams, but she had left the residence. And law enforcement noted blood droplets on the floor and did a welfare check and found her hiding in the bathroom of the apartment. The reason I bring that up, I think it is worth noting that he blatantly just lied to law enforcement about the victim's presence in the home, and certainly I would imagine he has represented information to the public defender's office for this hearing.
Okay, so I just want to make sure I had the recommendations. That's 10,000 on one, 5,000 on two, 1,500 on three.
That is correct, Judge.
All right. Anything further?
Nothing further.
Okay. All right, defense.
Yes, Your Honor. Mr. Tax is not able to afford that amount of bond that the state's recommended. He was previously working for 6 Rent-A-Car, is now going to be receiving unemployment due to mass closures of businesses. Your Honor, Mr. Tax is also injured. We are going to be requesting a photo order. He does have a bandage on his hand, and he did have marks on his forehead. The victim does have a separate address, but this is their marital home, and he doesn't have anywhere else to live. This is their shared home, with the victim being able to go live with her sister. Too, Your Honor, we're requesting that he be released standard pretrial with domestic violence conditions with no victim contact. He's lived in Broward County for around a year. He will stay here throughout the pendency of his case and report to all hearings.
Mr. Linder, aside from the January arrest that you referenced, are there any other priors from Mr. Tax?
In 2018, out of the state of New Jersey, he was arrested for harassment and striking a victim, and that was domestic violence in nature. That was dropped. In 2017, he was arrested for the same offense, domestic violence related, out of New Jersey. That was dropped. That is all I have.
Mr. Tax, today is just the bond hearing, so if there's anything that about the facts of the case or the background, that's going to be something for you to discuss with your attorneys after today's hearing. We're only discussing bond today, so I don't want you to say anything about the case other than that. Do you understand? Okay. All right.
I just want to ask about evidence, though.
That's
Mr.
gonna
Tax,
be-
not today, please.
That's gonna be for another day, Mr. Tax, okay? Today's just the bond hearing, okay?
I was just saying, because they're saying that there's no, you guys want to take photos, there's actually already.
Mr. Tax, not today, please. Thank you.
All right, okay.
We're invoking your right to remain silent. Use it.
Okay. All right, I'm reading the allegations of an probable cause affidavit, specifically the observation that was made by the police officers within the residence, as well as the, essentially inventory of injuries that were sustained by the alleged victim in this case. Based on the information that's been presented, we had a similar discussion in the case prior to this with respect to the bonds and the allegations. What the defense has requested is essentially an ROR to standard pretrial, since Mr. Tax is not able to afford any bond. If that is the case, then again, this may be one of those situations where a lengthier hearing will need to be had before the division judge. So in light of that, for today's purposes, the bond on count 1 is going to be set at $10,000. The bond on count 2 will be set at $5,000. And the bond on count 3 will be set at $1,500. There will be an order of no victim contact. I will sign the photo order that the defense requested. And if there is a further issue that needs to be addressed with respect to a bond modification, then Mr. Tax's attorneys will be able to file whatever motion they deem is necessary. Mr. Tax, for today's purposes, it's very important that you understand that the no contact order I'm putting in place means that you're not to be in the same place at the same time as the alleged victim in this case. That order also means no phone calls or text messages to this person. And,
has my
and,
phone.
okay, hold on, and no third-party contact or social media contact. Do you understand that? Okay, all right, thank you, sir, and good luck to you. All right, and now I'm going to briefly go off the record because we have one more case at Maine to address. That's going to be for Christopher Pinkney, so we'll be back on in one moment.
I'm sorry. When would be the court date?
You'll find out, Mr. Tax. They'll advise you of that as soon as it's set, okay? Thank you. All right. Okay, we're back on. While we're waiting on the last case to be prepared at the main jail, I'm going to continue on with a couple of our other hearings. I do have family members that are signed in for Edwin De Jesus on page 6. Have the public defenders had an opportunity to speak with Mr. De Jesus? Okay, all right. Will one of my deputies please bring them in, just to the podium? I'm sorry? Yes, they can come. And which facility is Mr. De Jesus at? At North Broward? Okay. All right, North Broward, can I please have Edwin De Jesus?
One moment, Your Honor.
Thank you, Deputy. All right, good morning, Mr. De Jesus.
Hello.
All right, I'm just waiting. They're bringing a couple of people in, and then I'm gonna get started with you. All right, Mr. De Jesus, you are before the court this morning on 4 charges. Count 1, aggravated assault with intent to commit a felony, domestic violence. Counts 2, 3, and 4 are each a separate charge of touch or strike battery, domestic violence. I find probable cause, and at this time, I will hear the state's recommendations, and then I will go to the defense before I go to anyone else that wishes to speak.
Your Honor, I'm going to be requesting $3,500 bond on 1, $1,500 bonds on 2, 3, and 4 in order of no victim contact. This is based on all the information I've been able to obtain about Mr. De Jesus, taking everything into consideration.
Okay?
I know my office had contact with witnesses that are present, and I was advised they were going to be coming to court, so I was aware of that. I know that Mr. De Jesus has mental health issues. He has 3 cases before Judge Porth right now.
Okay.
One is for the top charges: armed burglary of a conveyance, armed burglary of a conveyance, and burglary of a conveyance. And obviously, I understand that law enforcement was advised, if there wasn't any Scrivener's error, that Mr. De Jesus is taking his medication. Frankly, though, the behavior that's described in this report gives me it just is a description of instability, Your Honor, that has me concerned based on his current mental health state.
Okay. All right, thank you, Mr. Linder. At this time, I'm going to go to the defense for their recommendations.
Judge, at this time, if we could just hear from the family and get an idea of where they are, both in terms of his stability as they are best suited to judge that, and also their own security and how they feel about Mr. De Jesus at this point,
Okay, so,
potentially being out.
all right, so let me just ask, I have 4 family members who are here. Are each one of you going to be speaking, or is it just one person speaking for the group? Okay, are you mom? Yes. Okay, all right, so Mom, there's a couple of things that I want to tell you that I tell everyone who comes to first appearances, okay? Number 1, everything that we say here is being recorded. That means that it can be used against you and potentially him at a later date. And I say that to you because you're here without an attorney. I don't know if you've made statements to law enforcement yet or not, but it's something I have to advise you of, okay? All right, the other thing is, today is just the bond hearing, all right? So I'm not going to discuss anything about the facts of the case, the truth of the matter, anything like that, because I just want to address bond and release conditions today, all right? Okay, so what I'm going to do first is I will place you under oath, and then I'll hear what you want to tell me, okay? All right, will you please raise your right hand? Do you swear or affirm to tell the truth? Yes. Thank you. And now you can put your hand down. I'm just going to ask you to speak loudly into that microphone that's right there at the podium, and state your full name for the record. All right, and Ms. Rosario, go ahead and tell us what you would like to say today.
He goes to mental health court, and he's definitely schizophrenic. The medication he's on is not working.
Okay.
Should I say what happened or no?
I don't want you to say anything about the allegations in this case, okay? But you can tell me if there's anything that you think is going to impact the bond or release conditions, then you can tell me that.
If he can't come with us, I want him to live with my other daughter. She lives in Boca, and she just lives by herself.
Okay.
And her and him, together, they work to find both of them together, yes.
Okay. All right.
Your Honor, may I inquire briefly into a couple things from the mom?
Very briefly,
Very
and not
briefly.
about the facts of the case.
Not about the facts of the case. If he were to be released either to you or to his sister, do you feel like either party would be in danger of him being against someone, maybe physical or anything? And potentially he would be able to stay with you, right?
Yes,
And
yes,
you have no issues with him from that point.
no.
And in terms of the medication, is he able for medication?
Health, Henderson Mental Health Court, yes. Yes. His case manager just quit, so he hasn't even interviewed yet.
And we'll make bond argument at this time if.
All right, go ahead.
Judge, based on the representation from the family who's best suited to know how he will react and how he has been reacting, we'll be requesting that he be released on a standard pretrial release, calling twice a week, or reporting in person once per week, so there is that follow-up of him actually showing up. We would also request that he received a psychological evaluation at Henderson, followed up by any subsequent treatment that they see fits his needs, and also they're best suited to do that as well, since they are familiar with Mr. De Jesus and the treatment that he has been receiving. Whether he goes back to his mom, as she says, she doesn't have any safety issues with him coming back to the home, so I would be asking that he be released to her home. But alternatively, there could be an order that he remain at the sister's house if the court feels more comfortable with that.
I would agree. His family knows him best, and the people, his family felt it necessary to lock themselves in rooms until law enforcement got there. SWAT had to be brought in. Definitely, I would object him to contact being permitted. Now, if his sister wants to take him in, that's fine. I would object to any order that he has to stay with his sister, especially since she's not here.
Okay. All right. Okay. So, Mr. Linder, and like I hear what you just said.
Yeah.
That you have no objection to the sister taking him in if she were to agree to that. We
Oh,
don't
yeah,
have her
I'm-
here
I'm
to say
just-
today. So, if they're, I'm assuming that you're referring to some sort of a non-monetary.
No, Your Honor, I'll leave it in the court's discretion. I mean, my concern is, and I listen to everything his mom said. This incident there was no provocation. It appears that it just came out of nowhere.
Okay, Mom, I just want you to just listen for now, okay?
And-
All right.
So I'll leave. I made the recommendation, but obviously I'll leave that in the court's discretion.
Okay.
Your Honor is not willing to just let him out on a standard pretrial release, then Judge, you could order him to be on a level 2 with a GPS, which would secure him staying wherever the court decides for him to go. And it also adds an extra level of security to the family, if that's what the court is looking for. And I would also ask the state attorney at this time if they have any objection to Mr. De Jesus' case going straight to Judge Porth rather than being assigned to a regular division at this time.
Your Honor, I think there's going to be some time for that. I really don't want to get involved with felony cases, especially where they're going to go from here at a first appearance.
Okay, so something that I will just say for the record, because I've had this issue come up a number of times. In misdemeanor cases, I have the ability to transfer them directly to mental health court. For felony cases, I do not have the ability to do that from here. That's something that the attorneys would have to raise with the division judge and have a transfer order signed from there. But even with what's going on right now, that's still something that you're able to do, okay? All right. Let me ask you this, Mr. Linder. Since you told me that he's got those cases that are pending with Judge Porth, has he had any issues with failures to appear, any violations?
I'll check that right now, Your Honor. There's nothing to indicate through Judge Port's division that there were any violations or failures to appear, Judge.
All right, and now let me ask pretrial. I have a couple of questions for pretrial. If I were to place him on a GPS monitor, let's say level 1, would he still be able to, assuming that he contacted pretrial ahead of time, would he be able to attend any medical appointments? And say if I enter an order that he receive a medical evaluation, that doesn't prevent anything like that, right? Yes.
Special conditions I would write permitted to attend his medical appointment.
Okay. All right. All right, so here's what I'm going to do. In light of all the information that has been provided to me, okay, I see that there may be some underlying issues going on with Mr. De Jesus, and so I want to make sure that he gets the treatment that he needs. At the same time, based on the allegations that have been given to me, I have great concern for the safety of the family members. And I understand, and I've listened to everything that you said today, Ms. Rosario. I understand that you care about him, and that's why you're all here to support him, okay? But it is also my job as the judge to make sure that you and the community in general is safe, okay? So what I will do is this. Instead of a monetary bond, I'm willing to place Mr. De Jesus on pretrial supervision. However, that would be with a level 1 GPS monitor. When, in light of the order that's been set down by the governor and the situation that's going on, there should be no issue with it being a level 1 at this time. That will be, of course, since it's going to be a level 1, pretrial will have to verify the location he's going to be residing at. I'm not going to order that it be his sister's house, but it will have to be some address that's verifiable that is separate and apart from the family members who are the alleged victims in this case, okay? So it's going to be a level 1 GPS monitor. I am going to order that he receive a mental health evaluation within 10 days of his release. Yes, it is. I just confirmed that with pretrial.
Oh, it would?
Yes, it's going to be a special condition.
Okay.
He will be able to attend any of his necessary medical appointments. That includes the mental health evaluation. The basis of this is to keep him safe, to keep his family members safe, to make sure that he is getting whatever help he needs, okay? All right, it's going to be a level 1 GPS monitor. There will be a mental health evaluation done within 10 days of his release. And there is going to be an order of no victim contact for the time being. All right. There's there's four names total, I believe. I'll read them to you. We have Jose Morales, Evan De Jesus, Evelyn Rosario, and Arzu Narali. Mr. Linder, is that correct? That's what you have?
That is correct, Your Honor.
It's Arzu, A-R-Z-U, Norali, Noorali. Okay. All right. Now, I want everybody, hold on, Mr. De Jesus, I just need you to come back for a moment. We're not done. Okay. All right. If pretrial is not able to verify an address for him, then I need everyone to understand that he will be in custody until either his division judge orders otherwise or a verifiable address is found by pretrial. Okay, that's going to be on the record. And Mr. De Jesus, I need for you to understand that for the time being, this no contact order means that you are not to be in the same place at the same time as any of the alleged victims. That also means no phone calls or text messages to these people, and no third-party contact or social media contact until a judge says otherwise. Do you understand that?
Yes, ma'am.
Thank you.
here. They are the victims. They indicated that he would be able to live there if he couldn't live with his sister.
I heard what they said, and I have made my ruling. Okay?
Your Honor wouldn't be inclined to do no harmful.
I would not be inclined based on these allegations, absolutely not. That is not gonna happen.
It's a caretaker.
It's not going to happen, counsel. All right, so I'm going to place an ROR on each of these counts with the conditions of release that I've already stated on the record. All right, thank you, Mr. De Jesus. Good luck to you, and good luck to the family members. Thank you.
No, they're free to go.
All right. While I'm at North Broward, the next case that I'm told is ready is Denise Sparta.
North Broward, Your Honor.
Thank you, Deputy. All right, good morning, Ms. Sparta.
Good morning.
Ms. Sparta, you're before the court this morning on one charge of battery on a person 65 years of age or older. I find probable cause, and I will begin with the state's recommendations, and then I will go to the defense.
Your Honor, I'm requesting a $2,000 bond, no victim contact. Ms. Sparta was arrested in 2017 for aggravated battery against a victim over 65 and misdemeanor battery against the same alleged victim. Those charges were dropped.
Okay, all right. Go ahead. All right, I'm gonna, counsel, I'm just gonna ask you to, I don't know if that microphone's working, but I'm just gonna ask you something.
Speaking.
Thank you.
Here we go. Miss Sparta has lived in Broward County over 20 years. She is a nurse, Your Honor. She was taking care of the alleged victim in this case, her domestic partner husband, who had a fractured femur, and there was a verbal altercation, but no sustained injuries. As Your Honor is aware, that an arrest is not proof of guilt, that those charges were dropped. They shouldn't be considered into whether or not a release would be set. She does have a separate address that she can live at from the alleged victim, Your Honor, and she is able to work whenever she does get out. Her services as a nurse are highly needed right now. And Your Honor, we're requesting that she be released standard pretrial where she calls in twice a week in lieu of a monetary bond.
Is she actually working as a nurse right now?
No, but she is able to. She was providing care to her domestic partner who had fractured his femur.
But she's not
But
actually employed as a nurse right now.
No, but she's able to be employed.
Judge,
Yes.
Sergeant Carmen,
Are you ready on that other case,
she
Deputy?
has me on.
Oh, where's Craig? Give me one moment. One moment. I can see you, just one moment. All right. All right, the bond in this case for Ms. Sparta will be set at $1,000, and there will be an order of no victim contact. Ms. Sparta, I need you to understand that the no contact order means until a judge says otherwise, you're not to be in the same place at the same time as the alleged victim. If you reside together, then you'll have to find us someplace else to stay for the time being. That order also means no phone calls or text messages and no third-party contact or social media contact with that person. Do you understand?
I do. It's just all my belongings. I live with him.
Okay,
my
so
purse, my
that's all
phone.
right. So Ms. Sparta, let me address that, okay? If you
Okay.
need to go back to the residence to retrieve personal belongings, then you may do so one time, but it must be with local law enforcement. That means that you must call the local law enforcement agency in your area, and you will coordinate it with them. You're not to go there without them. Do you understand?
Yes, ma'am.
Okay, all right. Thank you very much. Good luck, ma'am.
Thank you.
Okay. All right. And Okay, so now we're ready to address our last case that we're going to do via Zoom at the main jail. So I'm going to go off the record briefly so that the attorneys have time to speak with this individual, and then we'll come back on to address that hearing. Okay, so let's go ahead and proceed. In light of Mr. Pinckney's refusal for today's purposes, I have been advised that the Public Defender's Office is going to waive his appearance. Once again, I've already found probable cause in Mr. Pinckney's case, so we're only addressing bond today. I do see that he has, looks like 2 no bond holds. Mr. Linder, I'll go to you first, and then I'll go to the defense.
Thank you, Your Honor. Count 1, I'm seeking a $5,000 bond. Count 5, $2,500 bond. Count 7, $2,500 bond. Count 8, a $5,000 bond. I'm sorry, count 9, $5,000 bond. Count 10 on the punishable by life offense, seeking a finding for first appearance purposes only, proof evident, presumption great. No bond. I provided the court and defense counsel with a supplemental report. There's also surveillance video placing him at the location. Count 12, $2,500 bond, and an order of no return to any of the incident locations.
All right, defense, I'll hear your response.
Judge, for purposes of probable cause first on count 1, what I said is that count 10 of the punishable by night, charge, I will just, he's not present, but we still be holding his right to remain silent and won't count as an citizen of the lawful officer.
Your Honor, briefly, as far as count 1, it's actually meant to be robbery with a weapon, which is actually a more serious offense that's on the findings. It's a first-degree felony. The weapon in this matter was the shopping cart, and it specifically describes that he was using it as a weapon.
Okay. All right. Thank you both. I'm going to leave the finding of probable cause in place. With respect to count 10, which is a charge for burglary with assault or battery, I have reviewed the probable cause affidavit in this case, and based on the information that has been provided for today's purposes only, I'm going to make a preliminary finding of proof evident presumption great and order that Mr. Pinckney be held no bond on count 10. That will be without prejudice for him to have the appropriate Arthur hearing before his division judge to further address that matter. Yes, that's fine. The objection's noted on the record. All right, and then in light of the, in light of the no bond holds that Mr. Pinckney has at this time, I will set the bond on count 1 at $5,000. The bond on count 5 will be set at $2,500. The bond on count 7 will be set at $2,500. The bond on count 9 will be set at $5,000. And the bond on count 12 will be set at $2,500. There will also be an order of no return, which will apply to each of the locations referenced in the multiple probable cause affidavits in Mr. Pinckney's case. I'll leave the other standard bonds in place at this time. All right. Thank you all for that. Okay. All right. The next on my list is Jennifer Paredes. Do we know which facility she's at? All right. Thank you. Okay, for my deputies at Maine, do you have Jennifer Paredes? Thank you. Good morning, Ms. Paredes.
Good morning, ma'am.
Ma'am, you're before the court this morning on 3 charges. Count 1 is burglary of an unoccupied conveyance, unarmed. Count 2, first-degree petty theft. Count 3 is criminal mischief. I find probable cause, and I'll hear the parties' recommendations, beginning with the state at this time.
Your Honor, Ms. Paredes has no history,
Okay?
and it's for that reason only, I'd have no objection to pretrial, but I do want to state, and I hope she hears this, with everything going on right now, because there's been a lot of discussion in this courtroom with the environment,
Yes.
going in other people's vehicles, other people's property, is a danger to the community, and it causes undue stress on people that are going through enough already to wonder who's been in their car, who's touched their car, have people coughed or sneezed in their car. So I hope that's something that's thought about.
Thank you, Mr. Linder. Defense, do you wish to be heard?
Yes, Judge. Miss Paredes is 19 years old, Judge. She lives with her family. We are requesting that she be released standard pretrial.
Counsel, let me just stop you right there. Mr. Linder has just recommended standard pretrial.
Right.
So do you have any objection to that?
Not at all, Judge. Thank
Okay.
you.
All right, so I'm going to place an ROR on count 1, and Ms. Paredes will be placed on standard pretrial supervision. There will also be an order of no return and no victim contact. Ms. Paredes, I need you to understand this is very important, okay? Number 1, you're going to be released today because I am placing you on standard pretrial supervision. But you must report in person to standard pretrial supervision. If you are released before noon today, then you can report to pretrial today. The paper that the deputy's given you has instructions on where you need to go. If you are not released by noon today, you must report to pretrial by noon tomorrow. If you fail to report to them as I have instructed you, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
All right. Additionally, there are going to be orders of no return and no victim contact. That means that you are not to go to or return to the location that is at issue in this case. Whether you know the alleged victim or not, that means no being in the same place at the same time as this person, no phone calls or text messages to this person, no third-party contact or social media contact with this person. Do you understand that?
Yes, ma'am.
All right, and finally, Ms. Paredes, I want to say, because Mr. Linder has brought it up on the record today, I'm showing that you have no prior history, and so I'm hoping that this will be an isolated occurrence for you in your life. Based on the circumstances and everything that's going on right now, understand that the decision to place you on standard pretrial supervision is being done generously in light of the fact that you have no prior history. But if I have to see you again anytime soon, you may not have the same result. Do you understand that?
Yes, ma'am.
All right, thank you, ma'am, and good luck to you. Ms. Broward asked for her to be put at the end of the docket. All right, is Grace Johnson still on medical loan? All right, and Princess Jackson is still on a medical loan.
Your Honor?
Yes.
I had one other female in the dock. I don't know.
It's Deborah Trebold. North Broward requested that
Oh.
she be placed at the end.
Got
Yeah.
it. Thank you.
Okay. All right. The next is Douglas Bethel.
Oh, we all have our moments.
Yes. Okay. All right. Do we have Douglas Bethel at Maine?
So, is it correct to say you started late?
Hi, Deputy.
Main jail, ma'am. Just give me a few minutes.
Thank you very much. Deputy, do you need me to keep going and come back to you, or is he going to come now?
Yeah, go ahead. You can go, ma'am.
Okay. All right.
And yeah.
Okay. So do we have my next one is Whitney Carter. Is she at Maine? All right. Let's keep going then. I'll go
It's
to
a mail.
Oh, excuse me. Okay. Tell me where our next satellite one is. We'll skip ahead a little bit. Oh, you know what? Looks like they're bringing him up now, so. Okay, that's all right. Okay, Mr. Bethel's here. All right, good morning, Mr. Bethel.
Good morning.
All right, Mr. Bethel, you're before the court this morning on one charge of touch or strike battery, domestic violence. I find probable cause, and at this time I'll hear. Mr. Bethel, can you hear me?
You breaking up?
Okay, I'm gonna do the best I can. Just try to listen. You are before the court on one charge of touch or strike battery, domestic violence. I find probable cause, and now I'm going to hear recommendations from the parties. I will begin with the state attorney, and then I will go to the defense.
Jessica Etienne on behalf of the state. He has one prior petty theft, 2018, which was a withhold. The state would have no objection to RR to standard pretrial.
Okay. Any objection to that from the defense?
No, Judge, thank you.
All right, so I am going to release Mr. Bethel and place him on standard pretrial supervision. There will be an order of no victim contact. Mr. Bethel, I'm hoping you can hear me because there's a couple of things that I need to advise you of. Number one, since I'm putting you on standard pretrial supervision, that means that you will be released today, but you must report to pretrial by noon tomorrow. If you're out in time today, then go to them today. If not, you must be there by noon tomorrow. The deputy's giving you a piece of paper with instructions on where you need to go. If you do not report to pretrial as I have instructed you, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
All right. There's also going to be an order of no victim contact. That means that until a judge says otherwise, you are not to be in the same place at the same time as the alleged victim in this case. That also means no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that?
Yes, ma'am.
Okay. All right. Thank you very much, Mr. Bethel. Good luck to you.
Thank you. Take it.
Order.
All right. Whitney Carter will be next.
Yes, ma'am.
All right. Good morning, Mr. Carter.
Good morning.
Mr. Carter, you are before the court this morning on one charge of touch or strike battery, domestic violence. I find probable cause, and I will hear the state's recommendation followed by the defense.
I'm not showing any priors, but based on the facts of the case, the state will be requesting a $1,000 bond.
Okay. Defense?
Yes, Judge. We're requesting standard pretrial. He doesn't have any priors. He works in car sales, and as Your Honor knows, that these businesses aren't open right now. The residence is in Mr. Carter's name, and the victim would be able to live somewhere else.
Sorry, did you say that he is a car salesman?
Yes.
As far as I have read, as recently as last night, the car dealerships are on the list of services that are exempt from the closure right now. Just for the record.
Okay, great.
Okay. All right. Anything else?
No, Your Honor.
Okay. All right. Based on the allegations in this case, I am going to set the bond at $1,000 and order no victim contact. With respect to the issue that was brought up regarding the residence and whose name it's in, I just need to make it clear, if the victim is not there, then Mr. Carter can return there. But if the victim is there and resides there, then he is not to be there. So, Mr. Carter, I need you to understand that the no victim contact order means until a judge says otherwise, you are not to be in the same place at the same time as this victim, as the alleged victim in this case. That also means no phone calls or text messages to this person, and no third-party contact or social media contact with this person. As you have heard me just say to counsel, if this person resides at this location and is still there, then you are not to be there. If the person has left that residence, then you are free to go there. Do you understand everything I've explained to you?
Yes, ma'am.
All right, thank you, sir. Good luck to you.
Harris?
All right. Freddie Harris Francis.
Good morning.
Good morning, Mr. Harris. Mr. Harris, you're before the court this morning on one charge of battery, causing bodily harm, domestic violence. I find probable cause, and I'll hear the parties' recommendations beginning with the state.
Your Honor, I was told that the victim was coming with the defendant's brother. I don't know if she's here.
Well, it's 10 o'clock now, and we're supposed to start at 8:30, so let's see if they're here or not.
Well, anyway, he does have prior domestic violence out of Leon County that was dropped due to the prosecutor there believing it was mutual combat. But outside of that, I didn't see any other priors. But based on the facts of the case, the state would be requesting a $500 bond.
500?
Yes.
All right, defense, go ahead.
They do live apart. The victim lives with her mom, and my client lives with his father, and his mother. He could afford the $1,000 bond. So
500?
Oh, yeah, he could afford a $500 bond.
Okay. All right, the bond will be set at $500, and there will be an order of no victim contact. Mr. Harris, I just need you to understand that the no contact order means until a judge says otherwise, you're not to be in the same place at the same time as the alleged victim. That also means no phone calls or text messages to this person, and no third-party contact or social media contact. Do you understand that? Here, Deputy, could you, I'm sorry, thank you. All right, you understand that, Mr. Harris?
Yes, ma'am.
Okay, thank you very much, sir. Good luck.
All right, thank you.
Next will be Rimsley Devlin.
How you doing, Your Honor?
I'm well, thank you, Mr. Devlin. All right, sir, you're before the court this morning on 4 charges. Counts 1 and 2 are each a separate count of aggravated assault with a deadly weapon, domestic violence. Count 3, aggravated assault with a deadly weapon without intent to kill. And count 4 is domestic battery by strangulation. I find probable cause, and I will hear the parties' recommendations, beginning with the state. Okay.
Your Honor, I'm requesting $5,000 bond each on counts 1 and 2, $2,500 bond on count 3, $5,000 bond on count 4, no victim contact. I would note the facts are aggravating, considering the allegation that he was carrying the victim's baby. I don't know if it's he's also the father of the child, but regardless, he was carrying a baby when he threatened the victim and strangled the victim. Additionally, Mr. Devlin is currently out right now on battery on a public transit employee and criminal mischief. He was arrested for aggravated battery against a pregnant victim and resisting without violence in 2014. That case was dropped. He additionally has resisting without violence 2013. He has other priors, Your Honor, but the ones I mentioned are the most relevant and recent with respect to this matter.
Okay, thank you. Defense?
If we do look at the probable cause, Your Honor, as it notes, is that Mr. Devlin acted in self-defense. He was not the one that was holding the knives. He was trying to remove the knives while he was holding a child. That the victim...
I'm sorry, where are you reading that? Because what it
Yes.
says is the defendant grabbed a serrated bread knife from the kitchen while the baby was in his arm. He lunged at Jasmine with the knife and advised he would kill her, their son, and himself.
Judge, if you go to the first paragraph of the probable cause, the victim advised that the defendant wasn't supposed to be there, but that she punched him in the face because she was in fear of him becoming aggressive.
Right? And then what does it say after that?
That he punched her in the face, but she was the one that was originally holding the knives.
And no, it does not say that. I will read the entire thing if you would like for me to, so that we have a clear record. It says, this is the law enforcement officer's statement. I observed the defendant holding a baby, Jasmine Blagman standing near him, and 2 knives and a knife sharpener on the floor between them. All parties were in the driveway of the above location. The victim advised the defendant entered her bedroom at approximately 2 hours. He was not supposed to be there, and she woke up to him standing over her. They began arguing, and she punched him in the face because she was in fear of him becoming aggressive. The defendant then punched her in the face. While she was on the ground, he had his knee on her chest and his hands around her throat. Jasmine advised she could not breathe. Jasmine went downstairs, and the defendant grabbed the baby and followed her. They started fighting by the front door, and the defendant choked her again with one hand on her neck and the baby in his other arm. She again advised she could not breathe. The defendant grabbed a serrated bread knife from the kitchen while the baby was still in his arm. He lunged at Jasmine with the knife and advised he would kill her, their son, and himself. Jasmine's mother tried to get him to settle down. At that point, the defendant advised he would kill whoever was closest to him if anyone called the police. Andrea was the closest to him at the time he stated that. Jasmine then snatched the knife from him when he was not paying attention. He proceeded to get a butcher knife and a knife sharpener rod from the kitchen. The baby was in his hand still. Jasmine then managed to grab the knife and sharpener from him again when he was not paying attention. They continued arguing outside, and she threw the knives on the driveway before deputies arrived on scene. Please continue with your recommendations.
Judge, they do live at separate addresses. And there are injuries to Mr. Devilon as well. We're gonna be requesting a photo order where he was also cut with knives. And he does additionally have evidence on camera that he is not able to access right now while in custody. We're requesting standard pretrial with domestic violence, no contact conditions, Judge, if they do, since they do share a child. If there could be either a no harmful contact or, in the event, because they both have custody, of a third-party intermediary to facilitate the change of hands of the child.
Based on the allegations of the threats that were made, which included threats to the child, based on what I'm seeing here, I'm going to leave that for a division judge to address separately. For today's purposes, I'm going to set the bond on count 1 at $5,000. Counts 2 and 3, I'll set the bond at $2,500. And on count 4, I'll set the bond at $3,000. I'll sign the photo order that was requested, and there will be an order of no victim contact. As I said, if there needs to be a modification to that, the division judge will be the one to handle it.
And Your Honor?
Yes.
I would ask, based on the threats that are alleged, and you referenced them, I would ask until further order of the court, no contact with the child that is referenced in the report.
Saying that would be a determination that the division judge makes.
I don't know that determination, I don't know that the state can make that request if Your Honor declines to order it at this point. There would have to be a change in circumstances, and at this point in time, I don't know what change in circumstances more than his threat to kill the child could possibly happen that would necessitate the court reversing a no contact order issue.
It's fine. I'm going to order that the no contact order apply to each of the alleged victims as well as the minor child in this case. If it needs to be modified, then the division judge can do it, as I said. Mr. Devilon, I need you to understand that the no contact order means until a judge says otherwise, you're not to be in the same place at the same time as any of the individuals I've referenced. That also means no phone calls or text messages to them, and no third-party contact or social media contact. Before you say anything else, Mr. Devilon, I want you to tell me if you understand the order that I've just explained to you.
Yes, you said no contact with the victim, no contact, no social media contact, or no third-party contact
With that person, correct?
with that person. Yes, I'm currently not working because of the corona, because both of my job did lay me off.
Right.
And I mean, if we can come to a different bond agreement.
So, Mr. Devilon, I understand what you're saying to me. I've heard the argument that was made by your attorney here today, If there needs to be a modification after today, then your attorney can file a motion for the judge to review and decide that, okay? That's gonna be it for today, though. All right? Thank you, sir.
So humpless.
All right, next will be Floyd Woods.
Reset.
Is it a medical
Recall,
reset?
I'm sorry. Recall, ma'am?
Oh, recall, okay, no
Into a side,
problem.
yes, ma'am.
Thank you, Deputy. All right, Dumesley Joseph. All right, good morning, Mr. Joseph.
How you doing?
I'm well, thank you. Mr. Joseph, you're before the court this morning on 4 charges. Counts 1 and 2 are each a separate count of violation of an injunction against repeat dating violence. Counts 3 and 4 are felony probation violations which have no bond holds. I find probable cause. The no bond holds will have to be addressed before the division judge shortly, but for today's hearing purposes, I will hear the parties' recommendations on counts 1 and 2, beginning with the state.
Your Honor, on count 1, I'm requesting a $2,500 bond. And frankly, it's just based on the nature of the allegations, and I'm referring specifically to the allegation involving the victim's mailbox. On charge 2, a $1,000 bond, no victim contact.
All right, defense.
Sorry, since he is going to be held no bond on the 2 cases and he is aware of that, I would be requesting that a nominal bond be set on the 2 violation cases. Based on the information that I have here and what I had seen, these are 2 misdemeanor counts. He is on a felony violation of probation, so we could just set $500 on each of the 2 counts, just for him to get credit.
All right, I will set the bond on count 1 at $1,500. Count 2 will be $1,000. And as I said, the no bond holds will be addressed with the division judge soon. Mr. Joseph, they'll set a hearing date for you on those so you can address the no bonds with your division judge. In the meantime, I need you to understand there is an order of no victim contact. Since this restraining order is in place, this should go without saying, but I'm going to say it on the record today so that it is very clear. The no contact order means you are not to be in the same place at the same time as the alleged victim. That also means no phone calls to this person, no text messages to this person, no social media contact at all with this person, and no third-party contact with this person. Do you understand that?
Say it one more time.
Yes, ma'am, I understand everything.
All right. Thank you, Mr. Joseph. Good luck to you.
All right, thank you.
Go ahead, Woods.
All right. You guys ready with Woods?
Woods is back, ma'am.
Okay, we can bring him up. All right. Good morning, Mr. Woods.
Good morning, Judge.
All right, Mr. Woods, you're before the court this morning on 2 charges. Count 1, aggravated assault with a deadly weapon, dating violence. Count 2 is touch or strike battery, dating violence. I find probable cause, and I'll hear the parties' recommendations beginning with the state.
Your Honor, I'm going to be requesting a $10,000 bond on count 1, a $2,500 bond on count 2. Pretrial release, no drugs, no alcohol or intoxicants, random testing. Our office had contact with the alleged victim. She advised us she is in fear. She also advised us that she believes he needs help with substance abuse. In 2016, he was arrested for aggravated battery against a pregnant victim. That was a different alleged victim. That was dropped. He has prior convictions for DUI, one in 2011, another in 2008 with property damage.
All right, defense, go ahead. Is the mic on?
Sorry, he does have a separate address from the alleged victim. He is beginning work tomorrow at Public stocking shelves. We're requesting standard pretrial. Your Honor, he's lived in Broward 4 or 5 years. And this is an allegation that where there's not any sustained injuries, the victim is also drinking in this incident, Your Honor.
The bond on count 1 will be set at $5,000. The bond on count 2 will be set at $1,000. If Mr. Woods does post his monetary bond, he will be placed on pretrial supervision. That'll be standard pretrial and subjected to random testing for drugs and alcohol. There will also be an order of no victim contact, as well as an order that Mr. Woods possess no weapons, firearms, or ammunition. Mr. Woods, I need you to understand that the no victim contact order means that until a judge says otherwise, you're not to be in the same place at the same time as the alleged victim. That also means no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that?
Yes, ma'am.
All right. And additionally, there will be an order that you are to possess no weapons, firearms, or ammunition. That means that until a judge says otherwise, if you are in possession of any of those items, they are to be surrendered to local law enforcement. Do you understand that?
Yes, ma'am.
Okay. All right. Thank you very much, sir. Good luck.
This way. Go ahead,
Okay. Rolando Gabarit Barcenas.
no, yes, ma'am.
He's a medical reset.
Medical reset, Your Honor.
All right. I think he was a reset from yesterday.
That's correct.
So for today's purposes, I'll make a finding of probable cause in absentia, and we will have him reset for bond.
Sorry.
All right, and next will be Neville Fulton.
Judge, he's a medical reset as well.
Okay, I do see that these are,
Sorry. Neville Fulton is here?
is this North Broward?
Yes, it is, I'm sorry.
Okay, he can come on in, thank you. He has no bond holds. All right, good morning, Mr. Fulton.
Good morning.
Mr. Fulton, you're before the court this morning on 2 charges. These are each a separate charge for a felony violation of probation. I find probable cause. And Mr. Fulton, your division judge has set no bond holds on these, which means that you'll go in front of the division judge shortly so that they can address that matter with you. All right?
Okay.
Thank you. Good luck, sir.
All right.
Jose Hato. Where is he?
North Broward, ma'am.
Oh, thank you.
North Broward.
Thank you.
You're welcome.
All right. Good morning, Mr. Hato.
Good morning, ma'am.
Sir, you are here today on a change of charge. And Mr. Linder, I want to make sure I have this right. It was originally aggravated battery on a law enforcement officer. It has been changed to battery on a law enforcement officer. Is that correct?
Yeah, sure.
All right. Go ahead.
Bond was set at 1,000. I'm just asking that it remain at 1,000. He's got bonds on his other counts. Also asked that the court impose the same release conditions that Judge Malika previously set.
All right. Any objection to the bond remaining as is?
No, Judge, thank you.
All right. He had pretrial?
That's what yeah.
Okay. Do you need me to write the specific conditions, or can I just write pretrial with? Okay. All right, Mr. Hato, since this is essentially a technical change of charge, I'm going to leave all the bonds and release conditions as they were already set, all right?
What were they set to before, ma'am?
You have, on this particular charge, you have $1,000 bond, and and if that bond is posted, you'll be placed on pretrial supervision.
Okay, so you said I'm able to do pretrial?
If the bond is posted, okay? And
You
this
just-
is count 2, so I'm assuming there's another count as well, okay? I just don't have that one in front of me today.
You just need to get your bondsman to give you an affidavit to change your charge. Okay? So contact your bondsman.
And then what do I tell my bondsman, you said?
You need an affidavit for change of charge.
Okay, and then that would release me on pretrial, like where I report to an office?
Yes.
Okay. Okay,
Okay. All right. Thank you, Mr. Hato. Good luck to you.
all right.
Next will be Amir Redwan.
Medical reset, Your Honor.
Okay. Thomas Lang. Name? Okay. Thank you. All right. Good morning, Mr. Lang.
Good morning, Your Honor. How are you?
I'm well, thank you. And Mr. Lang, you're before the court this morning on 2 charges. Count 1 is a municipal ordinance violation for causing a disturbance. Count 2 is criminal mischief. I find probable cause. I do see Mr. Lang has $25 bonds on each of these. Is the state seeking anything in addition to that?
The only thing I was gonna be requesting is the court order no return to this business, McDonald's.
Okay, and I'll go to the defense.
Your Honor, if Your Honor would be inclined to time serve him on both of these and resolve today?
Is there an offer?
There is not, due to there possibly being restitution issues on the criminal issue.
Okay, all right, so there's not an offer today to resolve. Is there a recommendation?
And yes, Your Honor, in that event, since the bonds are set so low and he hasn't bonded out yet, we're requesting standard pretrial. And since he would have resolved given the opportunity to today, but the state doesn't have an offer, furtherance that he is under the understanding that he'll show up at every court appearance as necessary by the court. That's it.
Okay, so, can we turn the speaker on for one moment? All right, Mr. Lang, your bond right now is set at, the total is $50, because it's $25 on each count. Are you able to afford that bond?
Can I get time served?
Well, the issue
I won't
is,
go back on that business or whatever the deal
Okay.
is, officer.
Mr. Lang, hold on.
Your Honor.
Hold on. Mr. Lang, I know you want to resolve the case, but the state does not have a plea offer for you today. That's something that you can address in the future, certainly, okay? I'm not able to accept a plea from you today on it. So I just need you to answer my first question. Are you able to afford the $50 bond, yes or no?
I can't even make a phone call out of here to my family because of the security, the way it's set up, okay?
Okay, all
I
right.
can't, I
Okay,
apologize.
that's all right, Mr. Lang. I don't need you to apologize. I just need to know if you can afford it, okay?
And for one, I was being arrested on the corner of
Okay,
Atlantic
hold on.
and Federal Highway
Mr.
on
Lang,
the east side.
Mr. Lang,
I was
Mr.
on McDonald's property.
Mr. Lang, you're not listening to me, okay? I don't want you to say anything about the facts of the case. That's not for today. All right, now just listen. Mr. Linder, does Mr. Lang have any prior history?
He does, Your Honor.
Okay.
And this is my concern with, just leaving it as the court ordering him to stay away. Last year, battery, violation of a pretrial release condition, that being a no contact order on a battery, resisting without violence. He was sentenced to 180 days in county jail, May 8th of last year. There was another battery arrest last year that was dropped. Twice in 2018, disorderly intoxication, resisting without violence. Yeah.
Judge, and considering the fact that the maximum restitution on this is the $200 for the way that it's charged, would Mr. Linder consider resolving in and ordering and reserving restitution as to the amount?
We're not gonna do that today.
Okay.
All right, in light of the circumstances, I will place Mr. Lang on standard pretrial with a no return order. All right, Mr. Lang, a couple of important things I need you to know. Number one, since I am placing you on,
I don't want pretrial release.
okay, well then I'm gonna leave the bonds in place. That's fine.
What's the pretrial release? What is it? Your Honor, what's the pretrial release?
Mr. Lang, that would require you to report in person to the pretrial one time once you're released, and then you would have to call in, I believe it's 2 times a week he has to call in? And you would have to call in to pretrial 2 times a week to report to them. And you would have to, if there's any future court dates, you have to come to them. If you don't abide by those conditions, then they can violate you. Do you understand?
Yeah, but how long is this gonna take?
It's while the case is pending.
It's a misdemeanor, like F3, right? Misdemeanor.
You have a municipal ordinance violation and a misdemeanor, yes.
Okay.
So-
What's the ordinance though?
It's for causing a disturbance in public. So, Mr. Lang, just listen to me for a minute, okay? Just listen. If I place you on standard pretrial supervision, that means that you would be released today, okay? but it also means that once you are released, you would have 24 hours to go report to the pretrial supervision office in person. You have to go there in person to sign the paperwork so they can sign you up. And then after that, you would have to call into them twice a week to report. They would explain all of that to you. Do you understand all that so far?
I guess I just don't understand why we can't resolve this right now.
Because the state does not have an offer. So I'm either going to leave the $50 bond in place, or I will place you on standard pretrial supervision. So which would you prefer?
I'll take the pretrial, I guess.
Okay, all right. So I'm going to ROR you on these and place you on standard pretrial. The deputy's giving you a piece of paper that has instructions on where you need to go. Understand that you have to report to pretrial supervision in person by noon tomorrow, and if you do not report to them, a warrant will be issued for your arrest. Do you understand that?
I guess.
Okay, and Mr. Lang, there's also going to be a no return order to the McDonald's location that's at issue in this case. That means that you're not to go to that location. Do you understand that?
Okay, I have a question for you, Your Honor.
Okay, go ahead.
There's a McDonald's here property, and there's a convenience store gas station right next to it.
Okay.
So there's two properties.
Okay.
All right. That means I'm not allowed on the McDonald's property.
That's correct.
Because the Valero property, I'm allowed on. Is that correct?
Okay, that's correct.
Okay, so whenever the deputy comes, because I'm gonna have somebody record this.
Okay, hold
when the
on,
deputy-
Mr. Lang. All right, you can do whatever you think is necessary. I just need you to understand that you're not to be on that McDonald's property, okay? All right, thank you, sir. Good luck.
I'm getting up.
Joe, Nico? Maine?
Main jail, he's approaching.
Thank you, deputy.
Do what you need to do.
All right, good morning, Mr. Nico. All right, Mr. Nico, you're before the court this morning on a misdemeanor capias that is related to a charge for trespassing. I find probable cause. And defense, what would Mr. Nico like to do today?
Mr. Nico would like to resolve, Your Honor, if you're so inclined.
All right, is there an offer from the state?
Yes, Judge. Adjudication, court cost, time served, no return to the Denny's, 2541 North 29th Avenue in Hollywood.
Okay, thank you. All right, so Mr. Nico, if you would like to resolve this case today, the state's offer to you would be an adjudication of guilt with time served, and there would be a no return order to the Denny's location that he described. Do you understand that?
Yes, madam.
All right, would you like to resolve and accept that offer today?
Yes, madam.
Okay, I'm gonna ask you a few questions before we're done. So, to begin, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you, and now you can put your hand down. And Mr. Nico, do you understand everything we've discussed so far this morning?
Yes, madam.
Is anyone forcing you to resolve this case?
No, madam.
Are you under the influence of drugs or alcohol?
No, madam.
Do you need any more time to speak with your attorney?
No, madam.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes, madam.
Have you ever been treated for mental or emotional illness?
Yes, madam.
Is there anything about that illness today that impacts your ability to accept this plea?
I agree, madam.
Is
I agree
there?
anything. I agree. I agree anything you offer me, madam.
Okay, but you understand everything that we've discussed, Mr. Nico?
Yes, madam.
Okay. All right, and do you understand that if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
My residence expires in 2021 as a Portuguese citizen, as an American resident. I have dual citizenship.
Okay, you have dual citizenship, okay.
Yes,
All
sir.
right. Okay,
Expires in 2021 August.
okay, all right. And Mr. Nico, what plea do you wish to enter today? Guilty or no contest?
No contest.
I'm sorry?
All right.
Mr. Nico, what was your-
Contest? No contest.
Okay, all right. All right, Mr. Nico, I accept your plea and find that it is freely and voluntarily given. Once again, your sentence in this case will be an adjudication of guilt with time served. And remember, there is a no return order to the Denny's location that we discussed. And you understand that?
Right, yes, yes, Your Honor.
Okay, all
Praise the Lord.
right. Thank you, Mr. Nico. Good luck to you, sir.
Mr. Bradshaw? Main jail, ma'am.
Thank you. All right. Good morning, Mr. Bradshaw.
Morning, sorry.
All right, Mr. Bradshaw, you're before the court this morning on a misdemeanor capias. This is related to a solicitation charge, and your division judge has placed a no bond hold on this case. Who's the division judge in this case? Can someone just check Mr. Bradshaw's case for me?
I think it's Judge Brown.
Okay.
If I may, looking in Odyssey, it
Yes.
appears that the court date notice was returned, so he wasn't given notice to appear.
Okay.
Whenever the capias was issued.
What's the prior history on the case?
There was a notice to appear 12/31 and a city information filed on that date. And a court date notice mailed out 1/4/2020. The court date notice was returned 1/27. There was an arraignment scheduled for 1/29 that wasn't held, and then the capias was issued on 1/29.
Are you really going through the garbage right now?
Judge, this is a solicitation of,
I see.
okay.
I see. It's just, it's not often that I see the division judges set a no bond hold on a capias. That's why I was inquiring as to the history. Does Mr. Bradshaw have any other pending cases? Is someone able to tell me?
Not that I see here in Broward, Judge.
All right.
Mr. Bradshaw is inclined to resolve if Your Honor would offer a time served.
Well, without the city being present or having anyone here, I'm not able to do that today.
Honor?
Yes.
It could have to do with, and I don't know if counsel looked at this, there was a letter that was sent to Judge Brown by someone familiar with Mr. Bradshaw. I can print the letter out for you if you'd like to see it.
Yes, thank you. Thank you.
Guessing that's Judge Brown's handwriting on the second page where she made the notes referencing the letter.
All right. Okay, for the record, I find probable cause. In light of the fact that I have Judge Brown's notes here as to why she set the no bond hold, I understand the circumstances that we find ourselves in as well as the circumstances of this case. I'm not going to lift Judge Brown's no bond hold. I don't think that would be appropriate. I think that that's something that Mr. Bradshaw's attorney will have to address with Judge Brown. However, if Mr. Bradshaw is interested in participating in the SAP program while he is in custody, I would be happy to sign an order as to that. I am told that SAP is still continuing to operate at this time. So, Deputy, can you just turn the speaker on for one moment, please? So, Mr. Bradshaw, Judge Brown has set a no bond hold in your case, and that's something that will have to be addressed with her on another day. But while you are in custody, are you interested in participating in the substance abuse program that they have there at the jail facility?
Not really, no.
Okay, all right, that's fine. So I'm gonna leave the no bond hold, and your attorneys will be able to address that with you and with Judge Brown, not today, but shortly, okay?
Alright.
All right, thank you, sir. Good
And
luck.
Judge, can you provisionally appoint the public defender so that way one of the public defenders who handles. Right. If, we can't be appointed, but someone else can. So if you could.
It's Steve Shade's office.
So if you could provisionally appoint so we can get the order so he can get represented.
Okay, he hasn't been, okay, that's fine. I'll sign an order appointing Steve Shade's office to do it. If one of you will draft that for me, then I will sign that. Okay, all right, thank you very much. Mr. Bradshaw, good luck to you, sir. Okay, thank you all for providing that information. I appreciate it. All right, next will be Isaiah Thomas. Thank you. All right, good morning, Mr. Thomas.
Good morning.
Mr. Thomas, you're before the court this morning on 3 ad charges. Count 3 is for fraud, use, or possession of ID of another person without consent. Count 4, false owner information provided for pawned items less than $300. And count 5 is for dealing in stolen property. And let me just look at something here. I have, Mr. Linder, on count 1, I'm just not seeing where that allegation is coming from. Okay.
Oh, yeah, because, Your Honor, you see Mr. Thomas's date of birth?
Oh, okay, it's a different ID, is that the issue?
It's been altered, or it's either someone else's or it's been altered because it has a date of birth of 8/7/58.
Okay. Okay. All right, okay.
Or he was just using someone else's ID. It's for information, not a...
I understand. All right, I find probable cause, and I will, I'm not sure what's holding Mr. Thomas on counts 1 and 2, but is the state seeking? Oh, he has a no bond.
Yes, and
Okay.
no, I'm not, Judge.
All right, defense, in light of the no bond hold that Mr. Thomas has, are you objecting to the standard bonds? Okay, all right, so I will leave the standard bonds in place. And Mr. Thomas, since you do have that no bond hold, that means that you'll see your division judge shortly, so you can address all of that at the same time. All right?
Alright.
Good luck to
I
you,
have
sir.
a question.
Yes, sir.
How do I get these charges with,
Your
the ID
attorneys
card?
can provide that to you. So I believe, and public defenders, correct me if I'm wrong, I believe that they're able to actually email the public defender's office directly from the jail facility to get the information that they need. Is that correct?
Not to our knowledge, Judge, but they will be able to call me. Mr. Thomas, this is Nicholas Soares. I was your attorney when you were in Judge Cora. Just look at 8649 as my extension, man. You could give me a call later today and we'll talk.
8649 by
Yep.
what time?
Yep.
What time?
By what time?
Whatever time, and they're routed to my cell phone, so anytime in the afternoon, whenever you're allowed to.
In the afternoon, okay?
All right, man.
All right, good luck, sir. Okay. All right, next will be Diamante Stovall. Mr. Stovall, is that me?
Hello.
Okay, all right. Good morning, Mr. Stovall.
Morning.
All right, sir, you're before the court this morning on 5 ad charges. Count 6 is for aggravated assault with a deadly weapon without intent to kill. Count 7, battery on a law enforcement officer. Counts 8 and 9 are for possession of weapon or ammunition by a convicted Florida felon. And count 10 is a felony probation violation, which has a no bond hold. I find probable cause, and I realize that the no bond hold will have to be addressed with Mr. Stovall's division judge, but I will hear the parties' recommendations on counts 6 through 9 at this time.
Your Honor, I'm requesting a $10,000 bond on count 6, a $5,000 bond on count 7, considering the alleged battery in the current environment. And based on well, the firearm that was found, or the assault rifle that was found in the vehicle, $7,500 bond on count 8, and the amount of ammunition that was found, a $7,500 bond on count 9.
Yes,
Hold on
Judge. Mr. Stovell had informed me that he had contacted a private attorney for purposes of representation in this case, Mr. Rubincheck. However, he understands that he's going to be held no bond on the violation of probation.
Okay.
So I don't have an objection right now to the bond amounts to be set at a standard amount, and then let his private attorney address everything together when they address the violation of probation.
That's fine. So then, since Mr. Stovall's attorney will be addressing everything at the same time, including the no bond holds, for today's purposes, the bond on count 6 will be set at $10,000. Count 7 will be set at $5,000. And counts 8 and 9 will be set at $7,500 each. All right, and then Mr. Stovall, that will all be able to be addressed at the same time by your attorney with the division judge. All right, good luck to you, sir. I'm sorry? I haven't called for anyone. Normally, it's the public defender's office who calls. It might be a different courtroom, just not us. Okay. All right, next will be Rafael Burgos.
Main jail, ma'am.
Thank you. Good morning, Mr. Burgos. All right, Mr. Burgos, you're before the court this morning on 3 charges. Count 1, burglary of an unoccupied conveyance, unarmed. Count 2, first-degree petty theft. Count 3 is criminal mischief. I find probable cause, and Mr. Linder, I'll hear the state's recommendation first.
Your Honor, I'm just pulling his history. If it's the same as his co-arrestees, I'll be making the same recommendation.
Okay.
Only thing I would ask in that event, Your Honor, so I don't have to go through my diatribe again, if you could just give him the same admonishment that you gave
That's fine.
his co-arrestee. Yes.
Yeah, we'll just verify.
Okay, yes, Your Honor, that's the recommendation I'd be making.
Okay, all right, any objection to standard pretrial? Okay, all right, so on count 1, I'm going to place an ROR. Mr. Burgos will be placed on standard pretrial, and there will be orders of no victim contact and no return. Mr. Burgos, I need you to listen carefully to some information that I'm going to give you, all right? Number 1, I am going to be placing you on standard pretrial supervision. That means that you're going to be released today, but you have to report to pretrial supervision by noon tomorrow, no later than noon tomorrow. The deputy is going to give you a piece of paper there that has instructions on where you need to go. I need you to understand that if you do not report to them as I have instructed you, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
All right, there are also going to be orders of no return and no victim contact. That means you are not to go to or return to the location that is at issue in this case. Whether you know the alleged victim or not, that means no being in the same place at the same time as this person, no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that?
Yes, ma'am.
All right, and Mr. Burgos, I had one of your co-arrestees in here earlier, and I told her the same thing that I'm going to tell you. In light of all of the circumstances and everything that is going on right now, you should not be out and about and in these situations. And I don't want you to say anything about the facts of the case. I just want you to listen to me. Because of the circumstances and your history, the state has allowed and agreed to, with the defense, place you on standard pretrial. If I happen to see you back here anytime soon, then we may not have the same result that we're having today. Do you understand that?
Yes, ma'am.
All right, Mr. Burgos, thank you very much and good luck to you.
Thank you.
Concord,
All right, next will be Brett Connor.
Connor. Main jail, ma'am.
Thank you. All right, good morning, Mr. Connor.
Morning, Your Honor.
Mr. Connor, you're before the court this morning on 7 charges. Count 1, burglary of an unoccupied conveyance, unarmed. Count 2, driving while license suspended. Count 3 is possession of a fictitious or unlawfully issued driver's license. Counts 4 through 7 are misdemeanor capiases that are related to charges for unlawful use of a false name or identity, petty theft, leaving the scene of an accident, and leaving the scene of an accident. I find probable cause, and I will hear from the parties. We'll begin with the state.
I think Ms. Hardy has.
Oh, pretrial standing? All right.
Defendant was placed on pretrial supervision initially in August of last year, case number 193646. Issues he violated that he was placed back on pretrial in November of last year, this time with a
Is he on a GPS monitor now?
He was, yes.
He was, or he is?
Technically, he is. That case when he came into custody.
Oh, yeah, well, I realize he's not wearing it right this
Correct.
moment. I just mean at the time of this arrest.
Yes.
Okay.
And just so you know, I did go through the case management notes. We've had issues with the defendant just not charging the minor. We had to call his mother to say to him, so you have to charge the minor. We can't let that happen. We must charge it for 2 hours a day. They've had to emit notice.
More than one time, okay. All right. In light of the information that has been provided to me, I am going to grant pretrial's request and revoke Mr. Connor's pretrial services in case number 193646 CF10A. In that case, I am going to place a no bond hold so that his division judge can decide how he or she would like to further address that case and how it will be handled. With respect to the case that's before me today, I realize that Mr. Connor is going to have a no bond hold in the 2019 case that I just addressed. He does have standard bonds set in the new case, but I do need to hear the party's recommendations on count 1.
Your Honor, requesting a $1,500 bond.
All right. Any objection to that from the defense?
Not necessarily to that, Judge, but in your general terms, I do want to put on the record that
Is the mic on?
I know that you're on. I apologize.
That's okay.
There you go. Mr. Connor has lived in South Florida his entire life. He is 20 years old. He was working at a couple restaurants, got laid off because of the coronavirus, and was proactive about finding a landscaping job to go to. He does live alone. He is responsible for all the bills in his house. I understand that Your Honor revoked his pretrial supervision on the 19 case. So just for the record, Judge, what I'll be asking for in terms of everything is that rather than giving him a no bond hold, that Your Honor give him a $5,000 bond on that charge for which he was already on pretrial for, and additionally then the $1,500 that the state asked for on count 1. But at least give him the ability to come up with the money and bond out.
So you're recommending $5,000 on the 2019 case, and then the standard bonds plus the state's recommendation on the new case.
Correct.
Your Honor, he already had a $5,000 bond on the robbery with the GPS, and the allegations are that he pistol whipped the victim and robbed him. It clearly didn't work. There's no reason to have confidence at this point that he will if allowed out of custody, that he will not continue to commit felony offenses, Your Honor.
All right, counsel, thank you for making your record. I'm going to leave the no bond hold in place at this time. Mr. Connors, division judge, can certainly address that with him and his attorney shortly so that that judge can decide what they would like to do with that case in light of the new case. And on the new case, I will set the bond at $1,500 on count 1, and I'll leave the standard bonds in place on the other charges. All right, thank you, Mr. Connor. Good luck to you, sir. Next will be Jamie Rodriguez.
North Broward, Your Honor.
Thank you. All right, good morning, Mr. Rodriguez.
Morning.
Mr. Rodriguez, you're before the court on one charge of battery on a person 65 years of age or older. I find probable cause, and at this time I'll hear recommendations, beginning with the state attorney.
One moment, Your Honor.
Okay.
Requesting a $2,500 bond. No victim contact, no returns, based on the age of the alleged victim, the allegations. Mr. Rodriguez's history, his most recent prior, it was 2010, but it was a strong arm robbery, and he violated probation. Nothing further.
Friday probation. I'm not on probation.
Okay. Mr. Rodriguez, just one moment, please.
And Judge, Mr. Rodriguez has been in front of Judge.
Is the mic on?
Oh, yeah, sorry. Mr. Rodriguez has been in front of Judge Porth before. This has been 9 years of him doing well. His probation was terminated. And we're requesting a standard pretrial, Your Honor.
So I can go get an actual mask. Hold on, because that's the one you have. I'll have the same one too. This one. That's the one you signed out for.
I understand Mr. Rodriguez has been doing well, and I'm happy to hear that. But without having more information in front of me, I'm a little bit concerned with that history and the new allegations that I'm seeing here today. I do see it does not appear that he has a permanent residence. Is that correct?
That's fine. Exactly. Put up for 5 minutes.
Your Honor, he does have a fiance in the area. I just, that does live in Broward. But,
That has an address.
I don't have her address offhand. Your Honor, if you'd be inclined to just place this on a brief recall and I can talk to him over the phone.
That's fine. All right,
Thank you.
Mr. Rodriguez, I'm going to place your case on a brief recall. The public defender here is going to call you on the telephone there at the jail facility so you can speak to her privately, and then I'll call you back up, okay?
All right.
All right, thank you. So the next case that I have is Willie Davis. Where is Mr. Davis? Okay. All right, good morning, Mr. Davis. Sir, you're before the court this morning on 3 charges. Count 1, aggravated assault with a deadly weapon without intent to kill. Count 2, possession of a weapon or ammo by a convicted Florida felon. Count 3 is possession of cannabis 20 grams or less. I find probable cause, and I will hear the parties' recommendations, beginning with the state at this time.
Your Honor, I'm requesting a $15,000 bond on count 1, a $5,000 bond on count 2. I can tell you His priors only just involve drugs. He does have a felony conviction for possession of cocaine, and they are dated. My concern in this case is it's not just an allegation of a threat with a firearm, but the firearm was actually discharged and struck the vehicle that the victim was in. Luckily, no one was harmed. And the firearm was recovered. Would also be asking for an order of no victim contact, no possession of firearms, weapons, ammunition, which he obviously is not supposed to be in possession of to begin with. Nothing further.
Realize the financial situation that you've advised that Mr. Davis has, but even if I place him on some sort of pretrial supervision, I'm just not comfortable with a straight ROR in light of the allegations in this case and the information that's been provided in the probable cause affidavit.
Could you text her and tell her to come down in about 10 minutes?
Process of just laying an argument. If Mr. Davis was in a different financial condition where $15,000 doesn't mean much to him, he just posted, he's out, and he has no supervision whatsoever. What we're asking for is actually a little more cumbersome on Mr. Davis, and it provides more security to both the community and everyone involved, but it eliminates the financial circumstances that are attached to it. Otherwise, the monetary bond it's just different treatment for different people depending on their economic situation. And for Mr. Davis, it's not fair for him to be left in custody under a situation where someone else, with the exact same facts, would have just been able to bond out.
Your Honor, and I would just say, Your Honor, the law is being equally applied to everybody. Financial situation is a factor for everyone for the court to consider. Your Honor's been provided with information about his, and Your Honor's taken into consideration, just like every other defendant on the docket this morning.
Just to put on the record, the reason for my hesitation on simply granting the defense's request, because I understand everything that you're saying to me, but this is a situation where, and I understand their allegations, and this is just the bond hearing, okay, to be clear about that. The allegation is that, number one, Mr. Davis was in possession of a handgun, which he should not have been in due to his current legal status, okay? Number two, he pointed it at a person, and more importantly, number three, he actually shot that weapon at the person. Thankfully, it did not strike the person. But then the report that I'm reading goes on to say that Mr. Davis himself told law enforcement that he hid the firearm in the yard at a residence that is not his. And that is how the firearm was recovered. So taking all of these into consideration, it just gives me great concern as to what's going on here. It's just each factor is more aggravating than the next. The bond on count 1 is going to be set at $7,500. The bond on count 2 will be set at $1,000. If Mr. Davis does post that monetary bond, then he will be placed on pretrial supervision with a level 2 GPS monitor. There will also be orders of no victim contact, and there will be an order that Mr. Davis is to possess no weapons, firearms, or ammunition. Mr. Davis, I need you to understand that that no contact order means that you're not to be in the same place at the same time as the alleged victim in this case. That also means no phone calls or text messages to this person, and no third-party contact or social media contact with that person. Can I have one of the deputies at Maine just turn it on briefly? Thank you. Mr. Davis, you understand the no contact order I've explained to you?
Yes, ma'am, I understand.
All right, thank you, sir. Good luck to you. Thank you. All right, next is going to be Tyrone Canamore.
Thank you.
Thank you. All right, good morning, Mr. Canamore.
How you doing?
I'm well, thank you. Mr. Canamore, you're before the court this morning on one charge of burglary of an unoccupied conveyance unarmed. I find probable cause, and I'll hear the parties' recommendations beginning with the state.
Your Honor, Mr. Canamore's history: trespass 2017, possession of cocaine 2016, resisting without violence, another resisting without violence. He has felony priors, but they're more dated, going back to 2005. State would be requesting a $500 bond, no victim contact.
No objection? All right, the bond will be set at $500, and there will be an order of no victim contact. Mr. Canamore, I just need you to understand whether you know the alleged victim in this case or not. That means no being in the same place at the same time as this person, no phone calls or text messages to this person, and no third-party contact or social media contact with this person. And can we turn the speaker on just briefly? Thank you. Mr. Canamore, do you understand that no contact order I've explained to you?
Yes, ma'am.
All right. Thank you, sir. Good luck to you. Isaiah Darcis.
Thank you, ma'am.
Thank you. Good morning,
morning,
Mr.
ma'am.
Darcis. Good morning. All right, Mr. Darcis, you're before the court this morning on 6 charges. Count 1 is battery on a law enforcement officer. Count 2, possession of weapon or ammo by a Florida delinquent. Count 3, carrying a concealed firearm. Count 4, possession of cannabis 20 grams or less. Count 5, resisting an officer obstructing with violence. And count 7 is obstruction or depriving of means to protect or communicate. I find probable cause, and at this time, I'll hear the parties' recommendations. We will begin with the state.
Your Honor, I'm requesting a $1,000 bond on 1, $500 bond on 5, and a $1,500 on 6, $1,500 bond on 6. Your Honor, I'm requesting a $5,000 bond on 2 because my greatest concern about these allegations is throughout this whole incident, this entire time, until he was ultimately he was in possession of a firearm. The entire time he was resisting, allegedly commit the battery, knocking the communication device off the officer. He had a firearm on his person that he wasn't legally allowed to be in possession of to begin with.
All right. Go ahead. Make sure that mic is on, please.
First, as far as PC goes for count 6, like the state just stated, that's he battered the officer as is alleged. He did not intend for the communication device to fall off. That's just something that fell off as a result of the battery, but that he never had the intent to deprive the officer of the means of communication as part of his actions. So that goes as to probable cause on that one count. Additionally, Judge, I understand the state's concern regarding the weapon, but I do think that it it highlights more the fact that he never used this while he was committing a crime as alleged in this case. It wasn't necessarily something that he was reacting to or that he was going for at any point. He just happened to have it on him at that time. So what we would be requesting in terms of bond, Judge, is two things essentially. He's able to afford about a $3,000 bond, which, depending on how Your Honor rules on count two, is just about what the standard amounts would be on the rest. But he's also able to be on a GPS monitor because he lives with mom at home and he is quarantining at the time. So if Your Honor would be willing to release him to pretrial services, put him on a level 2 with a GPS, allow him to stay at home with his mom during these times, I think it obviously enter the orders for no weapons, no guns, even though he's not allowed to have them or anything, no contact, the works if you will, but at least let him go just on the monitor.
Okay, so what are your monetary recommendations? What are your monetary recommendations then to go along with that?
It'll be a $3,000 top, so the ones that are already set, I would request $500 on count 1, $500 on count 2, count 3 and 4 already have them, 2, and then 500 on 5, and then depending on whether Your Honor goes with my argument on PC on count 6, then we would also be requesting $500 on count 6.
All right, I'm gonna set the bond on count 1 at $1,000. The bond on count 2
It's on? Is this on?
The bond on count 2 is going to be set at $1,500. I'll leave the $1,000 bond on count 3. Count 4, I'm going to place an ROR. Count 5, I'm going to place an ROR. And count 6, the bond is going to be $500. If Mr. Darcis does post that monetary bond, he will be placed on pretrial supervision. Is Mr. Darcis working, counsel?
Sir Darcis, are you currently working?
Yes, whenever the company calls for help, I go in, but I don't have a set schedule.
Where do you
right
work,
now.
Mr. Darcis?
I work with a rug company, we wash rugs.
Okay, so I would imagine that that's not operating at this time. So I'm going to set the GPS monitor on a level 1. And though it shouldn't need to be said, I'll say it anyway. There will be an order that Mr. Darcis possess no weapons, firearms, or ammunition. All right. Thank you, Mr. Darcis. Good luck to you, sir.
All right, thank you, Judge.
Is John Toomey still a medical on? Or is he back?
Let me check, Your Honor.
North Broward, Your Honor.
Oh, North Broward has him. I'm sorry? Who is that?
I don't know exactly what it was, but that's
Mr. Toomey, good morning.
Good morning, Your Honor.
Mr. Toomey, do you have private counsel on this case?
Correct, I do.
The person has already been hired?
I was only able to make a couple phone calls, but
Okay.
it's my previous lawyer, so I'm like 99.9% sure. My dad took care of everything and he started paying them and all that. So I tried to contact him myself when I was in the jail.
Okay.
For that hour I was, and I couldn't get a hold of him.
Okay,
his name's
what's
Mickey.
his name?
Mickey Broke.
Oh, Mickey, okay. Can someone, what I'm going to do, Mr. Toomey, is I'll place your case on a brief recall. I'm going to have one of the attorneys in the room try to get a hold of him, and then I'll bring
Okay.
you back up once I've heard back, okay?
All right, thank you.
Thank you. All right, someone call him, please. Rodriguez? Is he at North Broward? All right, let's go. Okay, North Broward, I'll take Jamie Rodriguez back, please. Okay, all right. So, council, now that you have discussed things with Mr. Rodriguez, go ahead and give me your additional information.
Mr. Rodriguez does have his fiance that's in Pembroke Pines. He just can't remember the address offhand, and
Okay.
he doesn't have a cell phone with the address.
Okay.
That being said, he is not able to afford a monetary bond and requesting standard pretrial.
All right. So, if he has a fiance that he can go live with, he just doesn't have the address. I assume he has her telephone number or some other contact information, correct?
Man,
Do you have her phone number? You can call her.
Tommy, they probably my wife DMZ. We just June 24, 2019. We just went through ceremony. I was on mission crash within the international committee, and I was
Mr.
supposed to get picked
Rodriguez,
up by
the judge
7:00.
just wants to know
They
your
did,
fiance's
they
phone
did.
number.
Like I said,
Mr. Rodriguez, Mr. Rodriguez, Mr.
Mr.
Rodriguez, Mr. Rodriguez, stop. Listen to me. Do you have your fiance's telephone number?
I don't got no way of contact with this
That's
woman.
not what I'm asking you. Do you have her contact? Do you have her phone
I
number?
just told you I got no way of contact with this woman.
So you
due
don't
to
have a
ceremony.
telephone number for her, and you don't know her address.
That's basically what the fuck I just said, yeah.
Okay, well that's very good. All right, in Mr. Toomey's case, or excuse me, in Mr. Rodriguez's case, I'm not going to place him on standard pretrial supervision. I do have some concerns. There are other things going on, and since he's not able to provide any of that information, pretrial wouldn't be able to verify any of that information anyway. So I am going to set the bond in his case at $2,000, and there will be an order of no victim contact as well as a no return order to this public's location. All right, Mr. Rodriguez, the no victim contact order means whether you know the alleged victim or not, you're not to be in the same place at the same time as this person, no phone calls or text messages to this person, no third-party contact or social media contact with that person. Do you understand that?
Yeah, I heard you.
All right, and the no return order means that you're not to go back to that public's location. Do you understand that?
I already know, man. I'm trying to go back to Asia anyway. I'm trying to go back home to Asia anyway.
Okay,
so
very
that's-
good. Very
Judge,
good.
just one more thing, based on what the court just stated as reason for not putting him on standard pretrial release, if there are other concerns, then we do need to proceed and have doctors appointed at this time, if that's what the concerns the court is having.
Are you requesting a psych
I am
evaluation?
not, Judge, but I'm just going based on what Your Honor said for the reason as to
So what are you requesting, counsel?
getting more clarity on what the basis is, what it is that the court thinks that's going on besides the facts of the case.
Counsel, you presented a history of mental health. I understand he has not had issues for the past 9 years, but based on the allegations and the information provided to me, I have a concern there may be some issues going on. Is that
Should
clear?
we not have to appoint doctors if the court has those concerns? Even if we're not the ones raising it, any party could raise those concerns and doctors would still have to be appointed for purposes.
And that would be done by a division judge. All right, thank you, Mr. Rodriguez. Good luck to you. All right, someone let me know if they talked to Mickey Rourke on that other case.
I got the number from the bar's website. I didn't have his cell phone or anything. I have the office number.
Okay, can one of you try to call him to see what's going on, please? I'll keep going. Do you have his cell phone number?
No, it's not that. It's just Mr. Toomey has a pending case. Mr. Roque is not the. Is not. That's why I didn't know if there was some confusion or. Because I don't
Yeah, no.
want the court to waste its time.
No, fine, we'll find out what's going on.
Okay.
Okay, next will be Norrance Baker. Which facility is Mr. Baker at?
Thank you.
Name? Okay. All right, thank you. All right, good morning, Mr. Baker.
Good morning, Your Honor.
All right, Mr. Baker, you're here this morning on a change of charge and an add charge. And so I just want to make sure that I have these correct, Mr. Linder. On count 1, the charge has been changed to attempted first-degree murder resulting in serious bodily injury. Is that correct?
That is correct.
All right, and the add charge, which I'm showing is listed as count 6, is possession of a weapon or ammunition by a convicted Florida felon. Is that correct? Okay. All All right, go ahead, Mr. Linder.
Mr. Baker first appeared before this court.
Yes.
It was on an arrest warrant where he was charged with attempted murder second degree,
Yes.
a bondable offense. Since then, the state has reviewed the matter, considered additional evidence, additional reports, and filed an information for attempted murder in the first degree, as you stated, which is a punishable by life offense. That is why, Your Honor, I provided the court with a supplemental report that was not provided to the court at the first appearance. As you can see, it's not the arrest warrant affidavit.
Yes.
And defense counsel. Based on the additional, the information contained in this supplemental report, I am going to be asking the court to make a finding of proof evident or presumption great on the attempted first-degree murder, and that Mr. Baker be held no bond on that count.
All right, and I will hear the defense's response.
Right,
And if you want the
Your Honor,
folio-
this,
Folio in this number whenever you
he was,
ready to go up here.
I just, was corresponding
Alright,
with the assigned attorney on this case.
I will.
And she
I
had
will.
spoke with Mr. Baker. She said that, originally he was
You're gonna get it on
charged
the text message when I
with,
text it to you right now.
with murder, and now it's gone down actually to an attempt. That.
Alright, perfect. Alright.
I don't think that's
All right,
correct,
bye.
counsel.
It might have said murder because they can't book someone for attempted murder.
Right, the
but
finding was for attempt. Yeah, it was for attempt.
Right, so, that being said, Judge, we're requesting that if Your Honor is, that for a proof evident presumption, great, hearing that, in order for a defense counsel who is on the case to adequately respond, that finding be reserved, so defense counsel can adequately prepare to argue it at a subsequent hearing.
This is just for a preliminary finding, counsel. If I do make that finding today, it would be without prejudice for them to have the Arthur hearing later on.
I would object to a finding being made today, Your Honor. And then as far as a bond being set, we're requesting a reasonable bond, Judge. He is a resident of Broward County. He was, I believe, previously bonded out.
Your Honor set a $350,000 bond and revoked his bond on another case. So he's being held no bond no matter what happens today. And the court, when it was a lesser charge, the court felt that a $350,000 bond was appropriate.
So, Your Honor, I'm requesting a reasonable bond be made, be set.
Yes, Mr. Baker.
Yeah. I was on pretrial release, and I went down to the police station to speak to a detective about the
So,
situation.
Mr. Baker, hang
Okay.
on one sec. Just listen for me,
Okay.
okay? I don't want you to tell me anything about the facts of the case. I understand we've already had one hearing together, okay? I understand what happened last time, and I believe that the pretrial services were revoked and a no bond hold was placed, right? So I
Yes,
think
a court order.
so you still have that no bond hold right now.
There's a court order, yes. The
Right.
judge actually didn't understand why there was a court order for a no bond hold. This is what I wanted to bring up. Like, they're only holding me because of this new case, and they weren't going to file, but they did file because they changed the charge.
Right.
So now I have a gun charge, and there's no gun on file. There's no gun that was confiscated from me or found anywhere. And also I have attempted murder case with a drug guy, a person on drugs.
Okay,
is saying,
hold
"I
on,
did
Mr. Baker. I don't want you to talk about any of the details of the case. Talk to your attorneys about that after the hearing, okay?
Okay.
Okay.
I mean, but that's the only thing that's holding me, and the bond is $350,000.
Right.
There's no way feasible that I could come up with $30,000, even a 10% to get out.
Okay.
I mean,
All right. Okay, thank you, Mr. Baker. All right, so I have reviewed the probable cause affidavit as well as the supplemental report that have been provided to me in this case. For today's hearing purposes, I am going to make a preliminary finding of proof evident presumption great and place a no bond hold as to count 1. That, as I said before, that is without prejudice for Mr. Baker's attorney to file the appropriate motion and have the appropriate Arthur hearing before his division judge so that matter as well as any bond issues can be addressed at that time, all at the same time. As far as count 6 goes, does the state have a recommendation on that?
Requesting $10,000.
defense.
Judge requesting, the level 1 electronic monitor with GPS for that count as was set with the original pretrial order.
What's your monetary bond recommendation on count 6?
Requesting, as far as monetary, we would be requesting not monetary, just a pretrial with GPS level 1.
All right, I'm going to set a $3,000 bond on count 6, and there's already a no victim contact order in place, so that will remain in place as I already explained. Okay. All right, thank you, Mr. Baker. Good luck to you, sir. All right. Did anyone get a hold of Mickey Rourke?
Yes, George, I got his cell phone. He was asking me to send him a picture of the PC. Unfortunately, since he was reset, I don't have access to his PC right now. But I do have his cell phone number where he wants to be reached at to appear by phone.
Okay. All right, let me go back to North Broward for a moment on Mr. Toomey's case. North Broward, could you bring John Toomey back up for me? And counsel, will you give me his phone number?
It's 954-854-7554.
All right, Mr. Toomey, I'm getting Mr. Rourke on the phone right now.
Okay.
All right, good morning, Mr. Rourke. This is Judge Cawthon. How are you this morning?
Oh, hey, Judge. How are you hanging in there?
I'm hanging in there. I've got Mr. Rourke. I've got Mr. Toomey here. He tells me that you're representing him on this new case. Is that correct?
Yes, that is correct. Unfortunately, the probable cause affidavit's not in the system,
Okay.
so we're unable to get it, and I haven't had the opportunity to see it. But I do know that he was in very bad condition in the hospital,
Yes.
and he's recovering. And I was hoping that the court would take that into consideration and perhaps put him on pretrial release at home with the monitor.
Well, Mr. Rourke, before I let the state jump in here, I'm just going to tell you that this is a very lengthy probable cause affidavit, and before you make that request or you hear my response, you might want to read it. So I know that Mr. Toomey's been, he was a medical reset for me yesterday. You know, I know that he got back from the hospital recently. So right now we're only having one magistrate session a day, so I'm only here in the mornings. If you want the time to review it and you want it reset to tomorrow so that you have that time, then I can do that for you. Otherwise, we're right here at the end of the docket, so I'm not sure how you want me to proceed at this point.
No, that's very fair. And with all things being considered, if it'd be possible, we could just reset that till tomorrow.
Okay.
And can I just ask, Judge? This is my cell phone number.
Okay.
If I could have, if it's possible that the PD could have a copy of it, that they could take a picture of it and text it to my cell phone. The PD. How many pages is it? Or if it could be emailed to my email.
Let me just ask, because I have everybody in the room, does one of the three attorneys I have in the room have Mr. Rourke's email address?
I have his cell phone. I could send the pictures
It's right
of the
here.
PC if I could get it.
Okay,
Oh,
all
yeah,
right.
I
So,
have his email.
Mr. Rourke, I will, what I'm going to do is I'll have one of them
I'm getting my
either,
copy. It's 2 o'clock.
okay, Mr. Linder's giving his copy right now to the public defender that's here, so they're going to send it to you. And I'll
Okay,
just,
thanks,
I
thanks,
can just
Judge.
have Mr. Toomey reset to tomorrow morning, so that way, you'll have an opportunity to review it. And if you want to appear by phone, that's fine with me. I'll just call you back on this number if that's what you want to do.
I would like to do it by phone, and yeah, and you could put us at the end of the docket. That would be great for tomorrow too, because I know our cases are more interesting, complicated issues. So
Okay.
That's okay.
All right, so Mr. Toomey, I'm not sure if you're able to hear all this discussion, but what Mr. Rourke's telling me, he's going to review all the paperwork. I'm going to reset you to tomorrow morning, so that way we have all that information to discuss tomorrow, okay?
Yes, ma'am.
Okay, all right, so Mr. Rourke, I'll talk to you tomorrow, all right?
Judge, thank you very much. Be
You're
safe,
welcome.
everyone.
Thank you, thank you.
Thank you,
All
Your
right.
Honor.
Thank you, Mr. Toomey. Yes,
Can we go off record just for one brief moment?
yes, give me 1 minute. All right, so can we just have Mr. Toomey, we're going to reset him to tomorrow morning, okay? I'm not going to put anything on here, we'll just have him reset on tomorrow's docket. All right. Okay, and do you need me to go off the record or you need sidebar?
Chill. So, yeah.
Off the record, please, just very
Okay,
briefly.
all right, we'll go off just very briefly, one moment. Okay, all right, we're back on. We have 2 cases left to address here at Magistrates this morning. The next on my list is John Isma. Which facility is Mr. Isma at? Maine, okay. All right, good morning, Mr. Isma.
Good morning, Your Honor.
All right, Mr. Isma, you're here this morning on a change of charge. And I just want to be clear here, on count 2, Mr. Linder, this was originally listed as burglary of an occupied dwelling, unarmed. It has been changed to burglary of an unoccupied dwelling, is that correct?
Not really, Your Honor.
Not really,
It's
okay.
just, that's just how the database entry works.
Okay,
Your Honor, I checked the information.
Yes.
It's filed as a burglary dwelling. It doesn't say unoccupied or occupied.
Okay.
But I checked the original arrest warrant that Your Honor imposed a $7,500 bond.
okay,
It is clear from the allegations that the home was occupied by the resident at the time. She saw, according to the warrant, Mr. Isma on her Ring camera system.
okay.
And that's how she was aware there was someone in the house. Either way, it's still a second-degree felony, Your Honor, so I just asked that the court impose the $7,500 bond that you originally said.
All right, defense, do you have any objection to me just leaving the bond as is?
For that, I do or don't. Was there a bond on count 1? What is the rest
There's
of
a
the bond?
$5,000 on another burglary of a dwelling, and $100 on a theft. There was also pretrial level 2 GPS, no victim contact.
Judge, what we would ask for is just to do the same as in the other one with the $3,000 bond on it. He already has a GPS level 2 to go along with any monetary amount that he does post. So,
Well, this isn't a second look, so there's no reason for me to reduce the bond unless there's some new information.
well, but there isn't a bond at all on this one, so I'm requesting a $3,000 bond to be set on the charge that's in front of you.
All right, thank you. I'm going to go ahead and reset the bond at $7,500, which is what it was originally set at. And I'm going to indicate on the finding sheet that this will be the same release conditions. So it'll be pre-trial release with all of the same release conditions that I had already set. All right, so Mr. Isma, I realize that this was like a little bit confusing. This is just a technical change. So I just want you to understand that I'm leaving your bond and release conditions exactly as they were before because this is only a technical change. Do you understand that?
Yes, and Your Honor, I'm not gonna be able to pay that bond. Any way you can resolve it today,
Okay.
Like,
I understand, Mr. Isma. The issue is that today's not a second look hearing. So if the bond needs to be modified, then your attorneys are able to file a motion and address that. Not today, though, okay?
I'm not gonna be able to pay it, but ain't no way y'all can give me the time, want to deal with, like I'm not gonna be able to pay the bond. Ain't no way y'all could resolve it. Just give me an offer or something.
So Mr. Isma, since this is a felony charge, I'm not able to resolve it here at first appearances. But if you're interested in resolving it, be sure to let your attorneys know that, and they will communicate that, and they'll be able to address that with you. Okay, good luck
That's
to you,
what I
sir.
want.
Thank you. All right, and then I have one last case here. We have Damian Ramirez.
That's a medical reset.
Medical reset, okay. All right, Ramirez is a medical reset, and,
From page 1, Judge, Ms. Trebold, we're resetting for tomorrow.
All right, so on Deborah Trebold's case, we're going to be resetting her. She's a medical reset. We will reset her to tomorrow morning.
That's the one at the North Broward?
Yes, that's
All
at
right, you'll
North
need to
Broward.
provide me the name so we can get that to the jail so that
Okay.
we're.
All right, so that brings us to the end of our magistrate docket for today. We do have 2 extradition hearings that Judge Malika will be presiding over shortly. All right, thank you, everyone. I'll see you tomorrow.
And Judge, we also have the 30 days.
Yes?
3 motions to release, Judge.
Oh, excuse me. I'm so sorry. It's underneath all my paperwork here.
Yeah. These.
Thank you. I'm getting ahead of myself here. All right. Okay, we do have 3 left. You're right. Okay, let's do these. So on my list here, I have Randall Opie,
Austin.
Do they know?
I don't
I feel like this
think
should be the
they
same.
know.
Conti. All right. All right. Good morning, Mr. Opie.
Good morning.
All right, Mr. Opie's here on a 30-day motion. State, have the charges been filed?
No, Your Honor, Mr. Opie is entitled to an ROR on these charges.
Yes?
I'm checking to see if there's anything else.
Okay. I want to just confirm there's nothing else holding him.
He does have a court-ordered hold on another felony case, Judge.
He does have a hold on another case? Is that a no bond hold?
Yes.
All right, so Mr. Opie, the case that I have before me here today, this is on, the 2 charges are for possession of cocaine and possession of drug paraphernalia. Since the state has not yet filed those formally, you are entitled to an ROR. What they're telling me is that you will still have a no bond hold on a separate matter. So if I grant the ROR and you remain in custody, that means that you will not be getting time served on these charges. So I can either give you the ROR, or I can leave the bonds as they are set so that you continue to accrue time served. So what would you like for me to do today?
ROR.
Okay, all right. So Mr. Opie, I will grant the request, and I will give you an ROR on these 2 charges. All right, good luck to you, sir.
Also,
Yes,
Your Honor,
yes, Mr. Opie.
they filed a motion for me to go for, to get a bond on my other charge.
Okay.
What's happening with that?
I don't have a date for you on that one, Mr. Opie, because that's not in front of me, but the attorneys will let you know when that date is scheduled with the division judges. I know they're trying to schedule them as quickly as possible, okay?
Okay.
All right, good luck, sir.
Yeah.
Okay, next will be Travis Stewart.
Stewart. Conti, Your Honor.
Thank you. All right, good morning, Mr. Stewart.
Good morning, Judge.
All right, Mr. Stewart, you're here on a 30-day motion. State, have the charges been filed?
Yes, Your Honor. The information has been filed.
Okay.
It is not reflected in Odyssey yet, so as an officer of the court, I can tell you we did receive an e-filing number from the portal upon filing the information.
Okay.
The filing number is 105-746-829. Most significantly on the top count, it was a change of charge to trafficking in substituted cathinones.
Okay. Is it still are there 4 charges that were filed?
Let me see. We filed a total of 3 charges: trafficking substituted cathinones, possession of substituted cathinones, and no valid deal.
Okay. All right. So okay. All right. So Mr. Stewart, since the state has filed these charges, that means that your next step will be to go before your division judge for an arraignment hearing. If there were any changes in the filings, then any changes to your bond will be reflected in the system later on today. All right. Good luck to you, sir. Next will be Israel Cannon.
Yes, again. Conti, Your Honor.
Thank you.
Good
morning.
All right. Good morning, Mr. Cannon. And Mr. Cannon is here on a 30-day motion as well. Has the charge been filed?
Your Honor, the state did file information. We downfiled it to a misdemeanor. So I have no objection to Mr. Cannon being ROR on the felony case number, obviously. I've spoken to defense counsel. In light of the time he served, I have no objection to him being ROR on the new misdemeanor case number that's been created. I provided that to defense counsel. He's provided an order if it's acceptable to the court.
All right, defense?
Yes, Judge, I provided the order to your clerk in court, and there's no objection to anything.
Okay, all right, then I will sign that order so that Mr. Cannon will be ROR today on the now misdemeanor case. Mr. Cannon, that means that let me just confirm first, there's nothing else holding him?
Let me make sure. I don't believe so, but I'll make sure.
Okay. Confinement's telling me that there's not. All right. Mr. Cannon, if there is nothing else holding you, then that means you will be released today. I just want to advise you that because you're going to be released ROR, that doesn't mean that that's the end of the case. So it will be your responsibility to remain in contact with your attorneys in the clerk's office so that you know about any future court dates you may need to be present for. Do you understand that?
Yes, ma'am.
Okay.
Your Honor, the only other thing I'd ask if you could advise Mr. Cannon, any no contact orders that were previously issued are still in place.
Okay, so Mr. Cannon, if there were any conditions of release that were previously put in place, for example, no return or no victim contact?
No.
Okay, well, if there were any of those put in place, then they remain, okay? Do you understand that?
Yes, ma'am.
Okay, all right, Mr. Cannon, good luck to you, sir. Thank you.
Thank you.
All right, now I believe that we're officially done with our morning docket. So everyone have a safe and healthy afternoon, and I will see you back here tomorrow morning. Thank you.